with it forever?
Not only does the victim live with it forever, I represent a lot of injured children, children with cerebral palsy, other types of brain damage. Frequently, those children are injured at birth. And because you do not see the intelligence of a child until the age of 4 or 5, if you limit it to 2 years, you don't even know the child has been injured unless it's causing a paralysis until the child is 4 or 5. And if you limit the statute, if the time too tightly, the person loses their right to sue before they even know they had an injury.
I think they're talking about a 6-year cap or limit as far as childbirth.
And what happens, and that's 6 years isn't even enough, because theoretically the child's right to sue could be lost before that child has a chance to file a suit on his or her own right.
So it should be left to age majority at least.
Sure, it is with every other type of injury.
Okay.
It is?
It sure is. You have until 1 year after you reach the age of 18. What if your parents don't believe in filing lawsuits? And then they die and you're 17 or 18 years old and your medical care costs are $100,000 a year and you've lost your right to sue because your parents either didn't believe in filing a lawsuit or didn't know that the doctor did something wrong.
What's your position, sir, on a proposed cap on pain and suffering awards?
I think that does not make sense. The pain and suffering in any given case varies from case to case. If you have a child that is brain injured and is ridiculed for the rest of his or her life, can never run, can never make love, can never have a child, spends the rest of his or her life, and unfortunately many of these children are living to the ages of 60 or 70. Nursing home care is $80,000 to $100,000 a year. Who will take care of that child? It'll be the taxpayer, if not the wrongdoer. And ironically, many of these large verdicts are because of the high cost of medical care.
But some in the medical profession insist that other states have caps and their systems are working.
Very few states have caps. The cap states include Indiana, California, and a couple of others, and they're working for the doctors, but they're not working for the taxpayers, because when the money recovered from the doctor runs out, that person becomes a welfare patient or goes under the Department of Social Services or under the federal disability, Social Security disability program. Somebody's going to pay.
But isn't that money brought to under a structured settlement? You buy an annuity and you pay it out under that rather than a lump sum?
The structured settlement is a different issue. Sometimes you can purchase an annuity which will produce maybe $5,000 or $4,000 a month to take care of that child, but depending on the injury, $4,000 or $5,000 a month might not be enough. I'm involved in representing a child who had what is called a neurotube defect. That's where the spinal column's on the outside, and the cost of taking care of that child, who lived for 4.5 years and lived every day of his life in the hospital, was $600,000 a year. And if the insurance of the doctor had not paid for that, the taxpayers would pay for it, or the hospitals would provide the care and not get reimbursed. Somebody's got to pay. We don't live in a society where these children, the brain-injured children, the quadriplegics, can be killed. Thank God. But if we lived in such a society, there'd be no cost. But if the wrongdoer doesn't pay, and historically in our society, the person who makes the mess is expected to clean it up.
Let me get back to our starting point where you